Hello everybody, Brian Hengesbaugh, partner at Baker McKenzie, here for part 3 of our tips in getting ready for GDPR implementation, which is coming up May 25, coming up very quick. We had a intro segment where we talked about tips for keeping a low profile. We had a second segment which dealt with how to respond to first-year audits when they come in, what things to expect, and how does that influence what you're doing from a readiness standpoint. And this segment 3 is to encourage you to think sort of short-term and long-term about what it is that you're going to do. If you've been engaged in a GDPR exercise, you know that there's a number of things that have come up in the course of the project that just, it's not going to be physically possible to get done by May 25. And it's really important to be realistic about that, not to get too distracted by that in these final weeks, not to throw off what you're doing to get ready to keep a low profile and get ready for that audit when it may come. This is a completely non-exhaustive list of the types of things that we're seeing, but wanted to give you a feel for it. Record retention is a big one. Record retention brings in lots of different issues. The privacy layer, of course, of GDPR is don't keep data for longer than you have a lawful basis to keep it. The other layer of record retention, though, is you have tax, employment, corporate, all kinds of other requirements that go into play for determining how long litigation defense, how long you might want to keep individual record types. And the answers can vary by individual member state, by business function, et cetera. So it's a very complex puzzle to sort out. So if you don't have the record retention puzzle completely sorted at this point, don't panic. Don't let it become a distraction from everything else that you can do and get done on a short-term basis. Put it on that longer-term path to really sort in an organized way. Newly discovered applications or activities. We had even just yesterday a client who just discovered new activities going on that dealt with the linkage between the parent company and the local subsidiaries around security monitoring. So that's something that you're not going to sort out in the next couple weeks. Don't panic about, but rather put it on an agenda to be sorted out in an organized way, because there's a lot of connection points, a lot of sensitivity, not just for privacy, with those types of activities. Vendor terms, we mentioned in the last segment. The market is such right now that those issues are not going to be finally sorted by May 25th. There's going to be some outstanding issues as vendors and customers are working to sort on what the arrangements are going to be like. Just make sure you've got prioritized the key vendors and make sure you're engaged in dialogue with them about finalizing some terms, and have on hand the terms that you're seeking in case you get a Data Protection Authority inquiry. Look for updates to member state laws. So there are member state laws coming. Only a few of the member states have actually adopted their local laws implementing GDPR. More is coming. It's going to impact employment issues, health medical data, other types of issues. So there's going to be more developments on that level, as well as e-privacy regulation expected in 2019, which would deal with things like email marketing, cookies, and a whole bunch of other related issues. And think about ongoing improvements. This is really an area where you're going to have continuous improvement that you need to do kind of across the program, across the company. Pay attention to enforcement actions as they arise, give you a sense of what the regulators really care about, look for new guidance, et cetera, and really set your mind that there's a sprint here, but then after that there really is going to be more work to be done.